I'm not going to address the facts of this case because, quite frankly, we don't have discovery. We haven't received anything. There is nothing in the arrest warrant. There's nothing in the indictment to give us any indication of what the facts are, so I can't address them at this point. They have been arrested now for 2 months, and we have not gotten anything. Ms. Weiss does inform me that the discovery should be ready very soon, so we're looking forward to getting that, but we don't have anything right now to address. I would like to address the shank or whatever the weapon that was found in the cell, first of all. I've talked to my client. I've gotten her side of this. She was in a cell with 2 other people. There were 4 bunk beds in there. Ms. Vilardi kept her belongings on top of a bunk bed that wasn't in use. This shank, knife, whatever it was found in a drawer. They said it was her drawer, but none of her belongings were in that drawer. I don't know how people knew when the bond hearing was because I didn't even tell Amy when the bond hearing was. I talked to her last Friday. She did not know when the bond hearing was. I could also point out that she was moved, I think, last Thursday. Thursday? Yes, ma'am. So she was moved last Thursday from one cell to another cell. And if she had a shank with her, she had to obtain it in that very short amount of time, or she had to transport it with her from one cell to another without a bag, without any, with her clothes and belongings all in her hands. This is not a small weapon. I've seen a picture Ms. Weiss provided. It's not a small weapon. It would be hard to hide this. And I would also venture to say with the comment that is in the report, if she said, I'm getting out of here one way or the other, if she did say that, that doesn't imply that she's a danger to other people. It implies she's a danger to herself. So I will leave that at that. I don't think that you can narrow down in a room full of 3 people who this actually belongs to. I will say also that when you're talking about bond and when you're talking about a flight risk, the Vilardis have been on bond for 8 years. They knew that they were suspects from day one. They had a billboard put up in 2017 looking for additional evidence. The sheriff in this case has been on news conferences talking about how he has suspects in the case. They were formally named as suspects in March of 2023. They did not hire an attorney. They did not run, excuse me. They hired an attorney. People who are guilty don't hire attorneys. People who are going to run don't hire attorneys. They, for 8 years, were able to move where they wanted. They could visit where they wanted, travel where they wanted, run if they wanted, move to a country that doesn't have extradition if they wanted, but they didn't. They stayed here. In fact, the Sheriff's Department was at the Vilardis' house on December the 11th, trying to get Ross Vilardi to turn on Amy Vilardi, trying to elicit a confession. You would think that if they had enough evidence that they would not be needing to try to elicit this confession. But they were there. They pulled Ross outside. They talked to both of them. There was no confession given that day. 2 days later, on the 13th of December, I met with Amy and Ross Vilardi because they felt like they were under suspicion. They were being harassed by the Sheriff's Department. That they kept coming to them over and over, kept naming them in these in the press conferences, and that they had done nothing wrong, and that they just kept coming back to them. The next day, I was retained. If they were going to run, they would have run. They knew, they named him as suspects. He's been on their property. They hired me. They did not run. The arrest warrant was issued the same day that I was retained. The very next day, the Sheriff's Department showed up at their house. Amy called Ross and said, you need to come home, they're here. Ross in turn called me. I was on the phone with Ross whenever he was arrested. Ross said, I think they're at the house. And I said, you're about to get arrested. I told him he was about to be arrested. He did not run. What he did was stall a few minutes so that his mother could get to the house to take care of their children. And then he went to the house. And as soon as he pulled up in the yard, the Sheriff's Department descended upon him. So I was on the phone. I heard them arrest him. He did not run. If that doesn't show that he is not a flight risk, if that doesn't show that Amy is not a flight risk, then I don't know what does. The confession that they were trying to elicit that day would have been their probable cause. It would have been something to neatly tie up this case with a bow on it. But all of these new cases and new arrests on old cases and cold cases require new evidence. And from what I've heard from the state, there does not appear to be any new evidence. They have a new way of looking at old evidence. So everything that they have got was available to them 8 years ago. Everything that they've got was known to Ms. Vilardi 8 years ago. She knew the evidence against her. In a press conference, the sheriff said that they've been emboldened by the Murdaugh conviction and the conviction of Alec Murdaugh based on circumstantial evidence. And that's what they have here. But the difference between the Murdaugh case and this case is that the circumstantial evidence in the Murdaugh case are missing guns that belong to the family that were used in the crime. Phone data placing Alec Murdaugh at the scene, a Snapchat video that placed him at the scene when he said he wasn't there. There's nothing like that here. There's no smoking gun. There's no, hey, somebody came forward and is now an eyewitness. And I would point out, too, that these, and I sympathize with the family. You have to sympathize with the family. I know they're seeking justice. But the fact that they say that they're afraid, were they afraid 8 years ago? They're not witnesses to this. They're not involved in this in any way. It would serve no purpose for them to be, you know, even if there was a reason that Amy would go out there, there's no reason for her to attack the members of this family. They're not a danger to her. The state has, in effect, tied our hands in this case without the discovery, without any configuration of what new evidence there is. Our hands are a little bit tied. We also don't get to have a preliminary hearing because they've indicted the case, so we don't get to have the ability to question the probable cause in that manner. I think we're entitled to a preliminary hearing. The arrest warrant must state that a crime has occurred and there's probable cause to believe that the person accused of the crime was the person who committed the crime. And there's just not, unless there's a separate affidavit that was attached to these arrest warrants, there's nothing like that in this. This is a one-sentence arrest warrant, which you'll have a copy of, that sets up no probable cause whatsoever. So I think the arrest warrant fails unless there is something that I don't know about. You know, we're seeking justice here, Judge, and I know this is a heinous crime. I just don't think that there's anything new that points the finger at Amy and Ross.